Okay, good morning everyone and welcome to today's webinar on 3 months to go data protection. My name is Henrietta Brealey. I'm the Director of Policy and Strategic Relationships at the Greater Birmingham Chambers of Commerce, and I'm joined here this morning by Cerys Wyn Davies, partner at Pinsent Masons, who will be really leading today's session. Before I hand over to Cerys to do her presentation, a little bit of housekeeping for you this morning. So first up, after Cerys's presentation, we will be moving into a Q&A discussion. So if you have any thoughts, reflections, comments and questions, pop them in the chat at any point and I will ask them on your behalf later on. Similarly, if you have any technical difficulties at all, pop them in the chat and my colleague Sophie, who you may spot listed as Chamber Events, will be very happy to help. Just to highlight to you as well, something that those of you who've been on previous Brexit webinars will be very familiar with, but for those who haven't, the Chamber, of course, is a not-for-profit business membership and business support organisation here to help connect, support and grow local businesses. At the moment, we're really focusing on how we can help keep business moving, both through the coronavirus pandemic and, of course, in the run-up to the end of the Brexit transition period. On the latter, we've teamed up with the West Midlands Combined Authority, Black Country Chamber of Commerce and Coventry and Warwickshire Chamber of Commerce on a series of totally free activity for businesses across the West Midlands area. You can find out more about all of this at www.greaterbirminghamchambers.com/Brexit, or as I say, pop a comment in the chat. Coming up, we have a series of digital workshops, just a couple of highlights over the coming weeks. We've got a session on importing goods at that 2 months to go mark on the 27th of October, and a session on intellectual property with Black Country Chamber on the 3rd of November. We're also offering a range of training courses. You may be aware that Chambers of Commerce across the country spend a lot of time working with businesses on international trade. We've got experts, documentation teams, international trade advisors, and more. And as part of that, they deliver a range of accredited and non-accredited training courses. These normally cost around £220 per delegate, but for the time being, we're able to offer these completely free of charge to businesses trading in goods who are looking to beef up on their Brexit preparations. And there are some great sessions coming up on fundamentals of Brexit planning, through to detailed look at customs declaration training, new import procedures and more. So do check those out. And finally, from me, we're running a customs support helpline. So all of those people that I've mentioned in the export documentation and international trade advisory teams, if you've got any questions from your business about importing and exporting goods in particular, but also more broadly around Brexit, you can call the customs support helpline on 0121 468 0831. And if they're not able to help, odds are they know someone who can get you answers to your questions there. That is more than enough from me though. Without further ado, I'm going to hand over to Cerys Wyn Davies, who is partner at Pinsent Masons and specialises in intellectual property, information technology and information law, and has extensive experience in advising industry. So I think you'll agree is just about the perfect person to be leading today's session on Brexit data protection. So over to you, Cerys.
Thank you very much. So I'll just share my screen. I just need to go back a few slides. So I'm not able to move the slides at the moment. Here we go. Okay, so good morning, everybody. Henrietta and I were discussing earlier that we'd hoped that we would have some deal by this stage that would mean that we could actually be talking about actually how things had been agreed with Europe as to how we would be processing data, but we're not there. So this morning what I'm going to talk about is, in the absence of agreement, the things that we need to be thinking about in order to enable businesses to continue to share data across Europe and beyond. So I'm going to look at, first of all, what does it mean in terms of GDPR compliance? What does it mean in terms of European operations as compared with your UK operations? Then transfers from the UK to Europe, transfers back from Europe to the UK, and then the broader aspects in terms of what it means for your privacy policies, the various agreements you have in place, and general awareness. So just a tiny bit of history to understand where we are with the data laws. The GDPR was a very big change, the biggest change we'd had in over 20 years, and came into force on the 25th of May 2018. And of course, businesses have been getting used to dealing with those requirements. And I think many people have said, what does that mean? Do we go back to square one? Well, we don't. But let's remember that one of the purposes of GDPR was to have harmony across Europe and to actually enable the sharing of data to the same standards. So where are we now in that respect? So we have actually left the EU, but we've been working under the transition period, which has meant that as regards data protection, things have remained pretty much the same as if we were part of the EEA. As from the 1st of January, that will no longer be the case, and we will have two quite separate regimes, the EU GDPR and the UK GDPR. And those are, as I say, quite separate from each other, but I will talk further about how they actually apply to your business day to day. So the good news for those who've put a lot of work into preparing for GDPR compliance and ensuring your business meets those standards, hopefully will be pleased to hear that UK GDPR, which will apply to most of your business activities in the UK, remains the same. Fundamental principles are the same. Obligations and rights, both of the organisations and data subjects, remain the same, at least at the moment, because there will be the freedom for the UK to make changes as time goes by. So I've talked about UK GDPR and EU GDPR. So what does that actually mean, and why do you need to be aware of both? Well, the reason for that is that the way that GDPR was prepared, it does have extraterritorial reach. So just giving some examples on the slides there, that if you're established in the UK, then you certainly need to comply with UK GDPR, and the ICO is likely to regulate all of your activities. So I think most of you will be well used to that scenario. If you have an establishment in the EEA, then you're going to need to comply with the EU GDPR insofar as it relates to those activities. So that again sounds quite accepted. If you have a business based in the UK, but then you've got branches in the EEA, you're going to have to comply with both, depending on where those activities are. But the real crossover comes where you may be based just in the UK, but you're offering goods or services to individuals, to data subjects in the EEA, or you're monitoring their behaviour there. So you don't have any establishment in Europe, in the EEA, but actually you do have customers there. Then, insofar as you're dealing with those customers who are resident in the EU, you have to comply with the EU GDPR, and insofar as you're dealing with customers in the UK, the UK GDPR. So it's worth remembering that you have those, at the moment, very, very similar regimes, but strictly they are different legal vehicles that you're complying with. And as you'll see flagged in red, what it does mean is that there's a difference in the regulator that you actually are responsible to. And the significance of this has been around, because of activities taking place throughout Europe, and there being regulators in each jurisdiction, and in, for example, Germany, several regulators, the way things have been organised is that you had one regulator. You could have the lead regulator that was appointed to deal with your activities, and therefore you responded to that regulator and you could build your relationship with them. But the ICO is now being taken out of that. So what we have now is a situation where, insofar as you are within EU GDPR, as I've just described, then you will be looking to a regulator in Europe, And insofar as you're looking at the UK, you're looking to the ICO as your regulator. So you do need to be thinking about where you have got activities in Europe, who would be the appropriate regulator for the activities that fall within EU GDPR. So it is a change, and it is an important one, although perhaps it's one that isn't as obvious in terms of thinking about the planning for GDPR. What we do expect is that there will be cooperation and collaboration between the ICO and the other supervisory authorities, the other regulators, so that there will be discussion about activities that perhaps extend between your European activities and UK, or affect UK data subjects and EU as well. And that is very much from the UK government's side, something that they really want to work on to ensure that dialogue. We already have it with regulators around the rest of the world, and they do always work together. So we would expect that to continue, but it does mean strictly as a business, you need to be reviewing your European operations and assessing, are you actually going to need to build a relationship with an EU lead authority to at least cover the EU as it stands once the UK has left. So that, as I say, isn't perhaps an obvious one, but is nevertheless an important one to make sure that you deal with that. Coming on then to perhaps the issue that is getting the most publicity, and that's the transfer of data. So we've been very fortunate with the way that data protection law has worked across Europe, in that provided you comply with the other requirements of GDPR, the data can flow readily between the EEA and the UK. So that has been something that you haven't needed to put any other measures in place. But what you will be familiar with if actually you're exporting, transferring, sharing data with organisations outside of the EEA, so for example the US, then you will be used to the fact that actually the GDPR says you can't transfer data to a country or territory outside the EEA unless you put in place a measure, and that those measures I'll come to. But the idea is that you must ensure that the data subjects that are your responsibility as a data controller are given the same level of protection for their rights and freedoms and ability to enforce those rights in the countries to which you transfer that data as they would if it was being processed in the EEA. And that is really important. It's a very fundamental principle. So how do we deal with that in a situation when we move outside of the EEA? So first of all, the European Commission has over the years approved a number of countries where you can actually export readily without having any other measures in place. And I've listed those on the slide, so I won't read through those, but Japan is the most recent to join that list. And the UK would hope, and I'll come back to this in a moment, that we will in due course be added to that list, and I'll give you some more information around that shortly. But in the absence of becoming an adequate territory, you then have to look to certain legal mechanisms or derogations which enable you to do that. And again, hopefully you'll be familiar with some of these through your dealings with businesses outside of the EEA, as I say, principally the US, but anywhere else around the world. So the first measure is the European Commission approved standard contractual clauses, and the way they work is that they are a standard set of clauses, and there are a number of sets which I'll come to in a moment. But if you use them in the form that they've been approved, that provides you with a legal mechanism to effectively endorse that transfer. So that is something that you can have in place to have the reassurance that the transfer can be made. Another option is bespoke clauses. So you actually assess the arrangement and you assess what needs to be put in place to deal with that. Those bespoke clauses, however, have to be approved by the regulator to whom you're responsible. So that clearly, it involves both a negotiation with the other party to agree the appropriate terms, but it also involves the process of going to the regulator and effectively negotiating with them to approve them. Then we have binding corporate rules, which are relevant to intra-group transfers. And again, organisations, if there are a lot of transfers happening across a group, will tend to look to put binding corporate rules in place. Then we have some other derogations that I'll come to in a moment. So where do we stand as a third country, which we will become on the 1st of January unless we have any other deal in place? As I say, adequacy is what we would then be looking for. The problem with adequacy is that it is within the European Commission's grant to decide whether or not to provide that. Logically, one would say that because we have the GDPR in place in the UK, we ought to be very well placed to receive that adequacy finding, and it would be the simplest thing for business, both in Europe and in the UK. But there are some issues, and what has been particularly drawn to everybody's attention as a result of the recent Schrems decision is that where governments have the ability to effectively access data of businesses, then that can present a real challenge to an adequacy finding. So we have the investigatory powers legislation, which is being held up as a potential area where we would be seen to not be adequate. So it isn't simple. And furthermore, it tends to take about 2 years to get an adequacy finding in place. So nobody should put store on that in the short term. The other possibility is a mini deal where we would agree something akin to the arrangements that need to be in place, the assurances that need to be in place to enable data to flow, that wasn't quite the adequacy finding, and it could be that that was put in place on a temporary basis, but that's the bit that we hoped we would have more news on by today, with only 3 months to go, but we haven't as yet. So let's look at what it means absent an adequacy finding and absent any other agreement being in place, and we're outside the transition period. Well, the good news for the transfers from the UK is that the UK has actually committed, first of all, to recognise all the adequacy findings that the European Commission has put in place. So if you want to send data outside of the EA, it's business as usual. So those countries that have been found adequate remain adequate. And insofar as any transfers are to Europe, then again, it's being regarded as that no further safeguards are required in terms of the transfer mechanisms. So that is a good position that the UK government has made it very easy for those flows to continue as previously. They've also recognised the binding corporate rules. They've also recognised the effectiveness of the standard contractual clauses for transfers outside of Europe. And what we do have to bear in mind that all of this is still subject to the potential to be changed, but certainly in the short term, transfers that are coming from the UK, it is business as usual. What is more difficult is transfers coming the other way. So we depend on Europe for our data flows in all directions, and a very large percentage, I think it's been put as high as 3/4 of the data flows from the UK are with Europe. So it is a very significant part of day-to-day business. We've talked about the potential for an adequacy decision. We've talked about the challenges by our intelligence regime being something that could put that at jeopardy. But the rule is that there are no transfers, therefore, unless there's an appropriate mechanism put in place. So what we then turn to as being the most appropriate mechanism, unless it's an intra-group arrangement where you've got binding corporate rules in place, or you haven't got them in place and it's still an intra-group transfer, then the most appropriate mechanism is the standard contractual clauses. I mentioned earlier there are a number of sets, and there are two principal types. The one is for controllers based in the EEA, and now it will be as a transfer and import into the UK to a processor, or where both parties are controllers, there's a different set. So it's important to have the right set. And I've included on the slide how you determine whether you're controller or processor, just as a bit more information there. The important thing to note today is that it is possible to enter into those clauses now, but effectively delay their implementation by saying that they only become effective on the 1st of January if there's no adequacy decision or no agreement reached with Europe on these data flows. So there is some sense in certainly looking at getting that in place. The other thing that we need to be thinking about now is not only having those agreements in place, but also following the Schrems decision a couple of months ago, which you may have been aware of, is that those standard contractual clauses were subject to some scrutiny. The privacy shield for the US disappeared totally. So if you are transferring to the US, you need to have the standard contractual clauses in place. But you now also need to assess the country to which you are transferring data to see whether any other measures need to be put in place. And we can talk more about this perhaps when we come to the question and answer session, but there's a lot more due diligence required in transferring data. For example, in the US, investigating whether there is risk to the data when it's in the US of it being actually accessed by the authorities in the US. And the same would apply to the UK. And again, wherever you are looking, and technical measures and contractual measures are needed to deal with that particular aspect. Another issue that we have, I've mentioned the sets of standard contractual clauses, but the one thing that is missing from those is if we actually had the processor in Europe and the controller in the UK. So there are no standard contractual clauses for dealing with that situation. And really the only other official way of dealing with it, the certain way, would be to draft bespoke clauses between the parties and then have those approved by the supervisory authority. The other option is to use one of the sets of clauses, but that doesn't give you the assurance of the legal mechanism. So that is an area that has no actual solution in place. And all we can do is our best until we have further guidance by drafting those clauses, perhaps trying to get them approved, but at least having the clauses in place, or using one of the other mechanisms and adapting those. But it is a gap in the current tools available to deal with these transfers. There are other derogations, which I've listed on the slide. I won't go through all of them, but the important thing to remember here is that these really are of limited use. They are intended for situations where you're not making regular transfers of personal data, but perhaps it's a one-off scenario where, for example, somebody is going to work in another country, and you might want to use it there to perform the contract with that particular data subject. There is a possibility to get consent, but you'd need it from every individual whose data you are transferring, and it would need to be explicit and fully informed. So that in itself really doesn't provide a regular mechanism for your data transfers. Just a little bit of information from some of the EU authorities in some of the European territories. I thought it was useful just to see what was being said from that side. And interestingly, again, not a lot of guidance has been provided locally where actually, if we think about it, the breach of GDPR would happen in Europe, because the ban is on the transfer from Europe to the UK. In Ireland, they have published guidance, and that was published earlier this year, essentially emphasising that you need to have an appropriate mechanism in place. And again, making sure that as well as having that mechanism, you need to have assurance that it's being managed in the right way. So it's not enough just to sign up to those standard contractual clauses. In practice, you need to ensure that the data is safe. Pretty much the same position from the CNIL, the regulator in France, confirming that these measures need to be there. So not much else in terms of the practicalities as to how it's going to work. In Germany, there's been a little bit more said, and I think some of this is quite helpful, confirming, as we'd expect, that we will be treated as a third country. Interestingly, they are saying that they consider the level of data protection in the UK as very high. So at the time of writing, they're saying that they don't think it likely that that there will be suspensions of data transfers to the UK, but very much encouraging people to put the right agreements in place. Interestingly, in the last point on that slide, they're also emphasising some of the points that I've got later in my slides, which is it's not just about the transfer mechanism. You need to be revisiting other aspects of compliance, and I'll come back to those at the end. The other thing just to bear in mind, so we don't forget, that although we have had it confirmed by UK government that we use the same mechanisms to transfer outside of the EEA as we have done to date, you also need to be thinking about it the other way round, because a number of countries will have agreed the scenario whereby they can actually import data, export from their country, import it into the EEA, but that now won't include the UK. So you need to investigate whether or not those other countries will allow the data to transfer to the UK, or whether a local mechanism is required in order to do that. A slide which I'm sure you don't really need reminding of, consequences of non-compliance are pretty high. It's at the higher end of the spectrum in terms of potential fines. We do now have the possibility that there could be a fine from Europe and from the UK. So those amounts could, in theory, double. So that is another factor to think about. But the reality is that the processing could be brought to an end, which it would be even more damaging for business activities. And it can result in claims from data subjects. And again, if you multiply those out, while it's a claim from one individual data subject may not be significant in itself, when you multiply that by several hundreds or thousands of people affected, it can be even more significant than the fines that we're talking about here. And certainly that has been the risk with some of the big factors that we're seeing of BA and Marriott hotels. The fines need to be looked at in addition to then the claims that are being made by data subjects. And the reputational damage as well is a clear additional factor. Last point before we come to the issues that you need to be looking at today is appointment of local representatives. It's a requirement under GDPR that you actually have a representative in territory to represent your activities insofar as compliance with GDPR, but also your communications with data subjects and also with the regulator. And therefore, if you have previously relied on UK as having your establishment here and therefore your connection for that purpose being from the UK, going forward, if you have any activities which involve processing in the EEA, you'll need to have a representative there as well. And the other way around, for businesses that are primarily based in the EEA, they will need to look at having a representative appointed for the UK as well. So steps to take now. We've talked in some detail about the transfer mechanisms. So the first thing that you need to look at is the data flows, to actually establish where is the data flowing between Europe and the UK or elsewhere, and then have a plan to put the contracts in place that actually deal with that. You also need to be thinking about data protection impact assessments. What impact is this going to have on individuals when the data is transferred in this way? Perhaps using due diligence questionnaires. And this has now all been brought to the fore even more so by the fact that the Schrems decision has emphasised that it's not enough just to have the legal mechanism. You also need to be doing your due diligence and understanding the circumstances in a particular territory as to accessibility to the data and the technical safeguards that can be put in place in order to alleviate that concern. You then need to look at the contracts and make sure that new contracts are being put in place to have these mechanisms. And then, as I mentioned, as the German regulator had pointed out, your privacy policies may not be referring to the export of data. You now need to be looking at that and correcting those. Together with your records of processing, again, where is the data that's flowing between borders now? And then the parts that I've mentioned around the appointment of a representative, but also your interactions with the regulators. Again, you need to work out how that is going to best take place. And then finally, as always with data protection, the governance issues and the training issues, to make sure that all of these issues are constantly under review and you're able to actually make changes as things hopefully move forward in terms of adequacy decisions or other agreements being put in place. So I know that's been a very quick run through of a whole host of issues that we're having to grapple with. I know we're going to now go into a question and answer session. So if any of those things aren't clear, or there's any burning questions that you've got that I haven't covered the issue, then please do ask away.
Fantastic. Thank you, Cerys. That's absolutely packed full of really useful information there. And for everyone watching, we will be publishing a recording of this on our YouTube channel. So if there are specific bits that you want to jump back to, dig into in a bit more detail, you will be able to do that there. But please do also ask away any questions, particularly if there's anything specific that your organisation are looking at the moment. Ahead of then, I wondered if I could ask you for some examples, if that's all right. So you mentioned that UK businesses may need to look at finding a local representative. Can you give us an example of what local representatives are, what kind of organisations those are?
Yes, so the local representative can be an individual, or it can be a company, it can be a consultancy, firms of solicitors. So it's finding, first of all, if there's an obvious representative that you can work with, another company, another organisation, or if that's not possible, then looking to the consultancies to do that for you. It is a very important role. As I mentioned earlier, it involves ensuring compliance. So it's being that communication point between Europe and the UK to ensure that, as far as your European activities are concerned, for the EU representative, and for the UK, the UK representative, but also being the person who receives any subject access requests or any other communications from data subjects. So it is a role that, depending on the nature of your activities, it could be quite a busy one. And as I say, very significant from your own perspective in terms of making that appointment, because it needs to be an organisation, an individual who you can rely on, both to handle those data subject communications, but also to deal with the regulator. And I think, you know, for those who have dealt with the regulator, it's really important that you understand the communications and are able to communicate very clearly and to represent the business's position.
Fantastic. And to add to that, we've had a question from Chris Roberts, who says, we have our ERP system based in the UK with our business contacts. We don't transfer our data anywhere else. So when we ship our goods to the EU, will we need an EU GDPR local representative?
So in terms of your data processing activities in the UK, that certainly in terms of establishment, all of your processing itself is happening here. But the piece that takes you into the EU GDPR is the fact that you are offering goods to EU residents. I'm understanding from the way that that's been described that that is the case. And that is the piece that GDPR has brought this extraterritorial impact. So it isn't just where you are based processing data, but the reality is that you're going to be processing the data of EU residents, albeit that you're bringing it to the UK. So you certainly would need the representative in Europe. And you would also need, yes, to be thinking about your privacy statements to make it very clear to the customers that their data will now be, well, will continue to be processed in the UK rather than in the EEA as was previously.
Okay, so that real focus on if you're processing EU citizens' data, then yes, you do need to look at having a representative in the EU. And also, as you say, those privacy statements, making sure that's really clear and up to date.
Yeah,
okay,
absolutely.
So brilliant. Some of our members have previously raised concerns about the fact that they use data centres with servers in the Republic of Ireland, for instance. Obviously, you know, we're increasingly in a cloud-based world. We're doing this remotely. Everyone's working remotely. Are there any questions that businesses should be asking or steps that they should be taking to sort of track down exactly where their data is being stored?
Yes, absolutely. And I think, again, it was always the case that we needed to do this, because even where you understood that processing was happening in Europe, it could often be the case that that wasn't the case, as you say, because of cloud storage, or just there was sub-processing going on where perhaps there was support being provided elsewhere around the globe and access was being given to the data as a result of that. So very important to ask those questions. Even more important now because of effectively the divide between the UK and Europe as far as the transfer of data. So you need to be understanding what mechanisms need to be put in place in order to achieve that. But then the additional layer that we have on this as a result of the Schrems decision, which means that even more so, we need to be doing this due diligence, constantly thinking, can we assure the data subjects that their privacy is being protected in the same way wherever it is being dealt with, and that they have the assurance around the enforcement of their rights as well. So the issue of where processing actually takes place is a very, very significant issue now.
So find out where your data is going and what's happening with it if you don't know already.
And what we are recommending is that people use a due diligence questionnaire now, wherever there are any transfers of data, whether it's to the US or to any other country. And I think we'll receive it from Europe to the UK, but it should equally be valid the other way around, that you're sending a list of questions that will actually establish those pieces around exactly what's happening with the data. And now what we're expecting more of is a dialogue not just around what's being done by the particular organisation you're working with, but also what their government's powers are to access that data. And that leading into a discussion around the technical measures, the encryption levels that can be achieved. And I think another important piece that actually sits over all of this, what GDPR brought for us was a discipline around processing personal data, not just an automatic, well, I've got a database of data and this can be used. It got us used to actually making sure that we had a legal basis for transferring that data, for being transparent, and only actually processing what we need to. And I think that is, again, a really important principle to avoid all of these risks around data transfers, that you need to be thinking, for this particular activity, for this particular processing that needs to happen in whatever the country is, do I need to actually send all of the data that actually I have got in my database, or can I limit the sort of data that's being sent? And I think that will become even more important with the concern around government access to data, to make sure that you're keeping the risk to a minimum, as I say, by encryption levels and by minimising the data or the type of data that is being transferred.
Certainly processing and transferring absolutely essential data to keep those obligations to a minimum. Just thinking about the majority of chamber members that we're engaging with around Brexit, a lot of them are small and mid-sized companies. They're primarily sort of UK only. And the main data they will probably have is customer details on, say, a CRM system that they utilise perfectly legitimately for completing orders and that sort of thing. With that sort of very simple business in mind, is there any essential pieces they need to be doing around the whole preparing for data protection post-Brexit transition? What are their sort of key steps?
Yeah, so I think similar to the question earlier around your data processing activities, it's remembering that even though you have everything based in the UK, if you do make any sales of goods or services, or you're monitoring the activities of individuals that are resident in the EU, that also brings you within the scope of the EU GDPR, as we're now describing the part that will be the rest of Europe, and then the UK GDPR for ourselves. So you can't just take the view that it's just UK GDPR in that scenario. And then it's looking at whether at first sight it seems that you're actually keeping all the data in the UK. It's going back again to, well, what is the support mechanism we have in place? So where do we get support for our CRM system? Is that, again, purely UK based, or is that happening from off UK shores? And therefore, if it is, we need to work out where. And again, we would need to have the right transfer mechanisms in place. And that probably does raise the issue of transfer. Transfer, traditionally, the word we think of as being actually moving something from one place to another. For the purposes of data protection, a data transfer is just, it can be accessed somewhere else. So if somebody, if your support is being provided, for example, from, let's say, South Africa, then if they can actually come onto your system and see the data of individuals on your system, that accessibility from another jurisdiction amounts to a transfer. So it's really important in these questions that you're asking of IT providers, database providers, that you understand how the services are being provided, because it's not always obvious, and therefore it is your responsibility as the controller of the data to actually get below the surface and understand the mechanisms there.
Brilliant. I've got two more questions before we wrap up, one of which follows very neatly on from that, which is from Mark, asking if Microsoft Office 365 claims to ensure all data protection concerns in the cloud when you follow the correct processes. Have you had a look at those from a Pinsent Masons perspective? And feel free to say if you cannot comment on individual bits of software, and whether you'd consider that to be adequate.
Yeah, so I'm not able to comment specifically on their governance and compliance. I think it raises an interesting question as to whose responsibility it is to get these things right. And I think businesses like Microsoft are really helpful in that they will anticipate these issues for you and provide you with mechanisms to ensure compliance. what you must remember is that as the controller of that data, though, it's still your responsibility to actually make an assessment of what they're telling you they've provided to provide that compliance. So not commenting on Microsoft, but we have over the years, particularly since GDPR has been in place, had various providers saying, that this is what we're providing as a mechanism to ensure compliance. And actually, when you look at it in detail, it isn't there. We particularly had it around when Safe Harbour disappeared for transfers between the UK and the US, which was pre the Privacy Shield. A number of organisations were trying to anticipate the flows of data from the US and offering solutions. And it was all very well-meaning and actually really helpful that they were thinking about it, but often it wasn't quite fully understood. So do look out. It's helpful to have the assurances, but ultimately remembering it is your responsibility to actually ask the right questions and then make sure that it does provide that full compliance position for you. And yeah, don't be afraid to challenge and ask for explanations. I think again, it's sort of an adjunct to that, but it's remembering that the particular issue I've identified has been around transfers from Europe to the UK. And here we are sitting in the UK. So for a lot of the solutions to ensure the flow of data for your business, it's quite likely you'll be going to the EU party saying, we need to put a mechanism in place. So it's a strange situation that actually you're offering a solution to them for them to put in place. But that's typically what we're finding. It's less the European businesses prompting the issue, and it's more the UK businesses saying we need a mechanism in place to allow this to continue. And of course, it's in your interest to do that, because the last thing you want is the UK company collaboration entity saying, actually, I'm going to have to stop because I haven't got the measure in place. But again, you just need to provide them with a mechanism, provide them with the explanation and the assurances as to why this does need to be implemented.
Brilliant. So that due diligence piece comes in regardless of who's making those promises. So I've got two questions on representatives before we wrap up, so I'm conscious of time. We've got a question from Amy asking if a subject access request or right to be removed comes through to the UK office, do they then have to send those back to the local representative, or can it just be handled through the UK office? And then a follow-up question from Chris asking where if there are any good sources to find an EU GDPR local representative for businesses, any good places for them to go to find out who they can work with there?
So on the first one, I think it's to deal with the subject access requests that come in. The important thing will be to work out, are you dealing with an EU resident or an UK? But from the question, I'm assuming it would have been relating to EU residents. If it comes to you, I certainly think you can be, if you've got the access to the data, which is likely to be the case, then you can certainly process that in the usual way. But I think the representative needs to be kept involved, so they still need to act as your liaison with the data subject alongside you. So if the data subject sent it to you directly, which is quite likely because you're the business that they're dealing with day to day, that's fine. But I would advise that the EU representative effectively should be responding with you, so that they're copied in, you're telling the data subject that you do have the EU representative, because that will be very important to point to that, and that you're ensuring EU GDPR compliance for those purposes. In terms of good sources, quite honestly, that has been a bit of a challenge. It's something we've been asked on a number of occasions, and we haven't found a list. I think there are people who advertise as providing that function. We don't at Pinsent Masons. I think the best place to ask is the ICO. So they have an extremely helpful website where you can raise issues with them. I would have a look at that, see if there's anything being posted that I haven't yet seen, and see if they can help you. Otherwise, if there is a particular country that that you have in mind, because that's where you think the principal activities would be, then do get in touch. And we have offices in a number of jurisdictions in Europe, and people within our offices, I'm sure, will be able to help to find somebody locally.
Fantastic. And the ICO website, as you say, is also a great source for those standard contractual clauses and other information in this space.
Yes, just on that, I think on the slide I flagged that the ICO's website actually has an easy way to complete those clauses on there, so it actually takes you through the process of completing them. So if you are in that position and need some support, then do have a look at that.
Fantastic. I'm mindful that this is obviously quite a complicated area. As you've said, there's still sort of some questions about the best way to find local representatives within the EU. With that in mind, is it pretty likely that one, some businesses entirely unintentionally will not be 100% compliant at the end of the Brexit transition period? And two, how strictly do you think this will be cracked down on? You know, do you think there'll be a sort of understanding view taken to those who are in breach accidentally as a result of this significant change, or do you think it will be a very sort of strict compliance regime?
Yeah, so we've had no statements on it from the regulators. Generally, they've moved away from situations where they give you a period of time to become compliant. So we had that when Safe Harbour disappeared in the US, and they set a time scale. And I think the problem with that is that naturally people wait till the end of that time scale to do anything. In reality, I think what is helpful is we have statements from one of the German regulators saying they still treat the UK as having a pretty good standards of data protection as a result of us having GDPR. And the indication there is that they wouldn't automatically be jumping on people and saying you're in breach and you're going to be fined and we're going to stop the processing. So we would hope, given the standards we have in the UK, that there will be some sense around this and actually a period of time to put things in place, and that the first piece would be that requirement to put something in place rather than regulatory action to fine or to stop the flows. I find it interesting that in Europe, and that's part of the reason I check in from time to time with colleagues there, that there isn't a very firm statement coming out from the local regulators saying you need to be acting now, you need to be putting these things in place. So we would hope with all of these areas that the regulators in each country will be reasonable. I think, as with all things data protection, the key thing is to be shown to understand the issue, to be doing your assessments of the data flows, identifying where you need to be taking action and getting that action underway. So where the regulator is most lenient is where they can see that despite the fact you haven't completed the process, it is well underway and the intentions are there that this is going to be completed. So that would be my recommendation, is even if it's not there for the 1st of January, to make all efforts to have these things in process and a good way in process. And one of those things is having the dialogue with your EEA counterparts to understand what is going to be put in place.
Fantastic, thank you. So do that due diligence, check in with your counterparts, what's happening, start getting things started, even if it's not perfect on the day. And of course, we are still waiting to see what happens, what does or doesn't come out of a trade deal. But making sure this is all in process, just for that safety, that backstop, it will be really, really important. You've kind of already answered this, I suspect, but I'd like to pose the challenge to you to leave us with your final one piece of advice. If you could just give just one piece of advice to delegates on this agenda, what would it be?
I think it's understand what's happening to the data for which you're a controller. So knowing where those flows are, knowing who's handling it, and the extent of its transfer across boundaries, but reviewing data flows and actually having that absolutely clear is the first step in so many things to do with data protection. So I think that is the first and foremost thing to make sure you're doing now.
Fantastic. Thank you so much, Cerys, for all of your advice and guidance today. As I say, we will be publishing a video of today's webinar. So if any of you would like to go back, have a look, double check what you may have heard, that will be available very soon. Thank you again. If any of you have any further questions or other areas of Brexit that you have concerns on, please do either get in touch with your relationship manager, or if you're not a member of the Chamber, you can drop a note to kbm@birmingham-chamber.com. That's KBM standing for Keep Business Moving. So thank you again for joining us today. Thank you, Cerys, and wishing you all a very good day and rest of the week.